For those of you joining, welcome. We're just going to give everyone a couple minutes to log in, okay? I see we've got like 14 people that are slowly joining in. We're at about half of the participants, so I'm going to give it like another minute or so. All right, for the sake of time, I think we're going to go ahead and get started. I'm sure people will continue to trickle in. Hello and good afternoon. On behalf of the Animal Law Section's Wildlife Law Committee, welcome to our presentation of For the Wild and For Us, how advocating for sound policy leads to better outcomes for wildlife and communities. Thank you, those of you that are on, for taking the time to join us, and thank you to our wonderful panelists that I will get to introducing in a little bit. As always, there's a little bit of housekeeping before we can get started. For those of you seeking CLE credit for this course, the code is 8522. Again, that's 8522, and that gives you 1 hour credit. It's your responsibility to self-report on the Florida Bar web portal. We will welcome your questions, and we will answer as many as we can get to with the time permitting via the Q&A chat option in Zoom at the end of the presentation. Feel free to go having them come in, but I'm only going to look at them at the end to start picking for questions at the end. We have a remarkable panel of amazing women dedicated to fighting for the environmental justice of our state. So let me get started by introducing them to you now. First, I have Lauren Jonaitis, is the Senior Conservation Director of Tropical Audubon Society, a nonprofit organization whose mission is to protect, conserve, and restore South Florida's ecosystem by working closely with local governments and other stakeholders, and by fostering wise stewardship of native habitats, birds, and other indigenous wildlife. Her background includes science communication, environmental permitting policy, land use, planning, and coastal ecology. She serves on the steering committee of the Biscayne Bay Marine Health Coalition and is a board member of the Everglades Coalition. Lauren received her bachelor's degree of zoology from the State University of New York at Oswego and a master's in biology with focus on conservation biology and population ecology from Bowling Green State University. Lauren will be setting the stage for our conversation by providing information about the South-Dade Logistics and Technology District and the Miami Wilds Project, and discussing the environmental concerns of each project. Next, we have Elise Bennett. She is the Florida and Caribbean Director and Senior Attorney at the Center for Biological Diversity, where she advocates for the region's most endangered species and ecosystems. Born and raised in Florida, she holds a law degree and a certificate of concentration in environmental law from Stetson University College of Law and a bachelor's degree in environmental science and policy from the University of South Florida's Honors College. Before working at the center, she served as judicial staff attorney in the 13th Judicial Circuit Court in Hillsborough County. Elise will be speaking about the Miami Wilds Project, focusing on Federal Endangered Species Act and National Environmental Policy Act, and how the absence of those reviews affected the overall project. Then we have Elizabeth Fata-Carpenter. She is the Executive Director of the Everglades Law Center. She focuses her legal practice on greater Everglades restoration, water quality, climate resiliency, and other environmental issues in Florida impacting communities and the environment. Elizabeth is a native Floridian and grew up along the Indian River Lagoon. Elizabeth obtained her bachelor's degree from the University of Florida and her law degree from the University of Miami, magna cum laude, Order of the Coif. Before joining the Everglades Law Center, Elizabeth spent time providing environmental education at Oregon Caves National Monument, working with salmon aquaculture in Kodiak, Alaska, and implementing environmental justice efforts here in Miami-Dade County. Elizabeth is the chair of the Village of El Portal Sustainability and Resiliency Task Force. She represents the Village of El Portal as a member of the project delivery team for the Comprehensive Everglades Restoration Project. And in 2020 and 2022, she was Village of El Portal Citizen of the Year. Elizabeth will be discussing the South-Dade Logistics and Technology District, a project that was proposed outside Miami-Dade County's urban development boundary line, a boundary that hasn't been expanded since 2013. I applaud each of you for the outstanding work, and I appreciate you taking the time out of your very busy schedules to be here and educate our section and our committee. And so at this point, I'll pass the baton to Lauren to get us started with the actual presentation. Let me go ahead and put up the PowerPoint, which I should have put up already. Hold on. This worked when we started, of course. Hold on. Let me go back. It can't be tech unless it gives us a little bit of an issue. All right, try this again. Here we go. So that's our title. These are our wonderful speakers. And here's where Lauren gets started.
Perfect. Thanks, Yvette. All right. Thanks for the great introduction. So as Yvette mentioned, I'm Lauren Jonaitis. I'm the Senior Conservation Director with Tropical Audubon Society. And for those not familiar where Tropical Audubon Society is located, we're in South Miami. We're one of the oldest nonprofits in South Florida. We're turning 78 years old. But we actually trace our roots back to the Coconut Grove Audubon Society. So we potentially could be over 100 years old. And our mission is to protect and restore South Florida ecosystems, focusing on birds, other wildlife, and their habitat. So the first project we're going to be talking about today is the Miami Wilds Project. So for those of you that are, in Miami, you might have heard of this project. It was proposed outside of Zoo Miami. So the map on the left is showing the project footprint in red there. Zoo Miami is at the bottom southern portion, and they were proposing this water theme park. So it was about 67 acres where they were going to put a water park right where the Zoo Miami parking lot is, so where that larger half circle shape is. And then they were going to have some overflow parking, right? Because you're moving the Zoo Miami parking lot. Where is everybody going to park if they build this project? So they had to use other locations. This was a really big concern for us because if you notice all that green space on the surrounding area on the map on the left, that's called the Richmond Pine Rocklands. So pine rocklands are a globally critically impaired ecosystem. What does that mean? That means that there's only 10% left of this ecosystem in the entire world and 1.2% of the ecosystem remaining outside of Everglades National Park. So that green area you're seeing there, the Richmond Pine Rocklands, that's part of that 1.2% of pine rocklands outside of Everglades National Park. So what happened here is the county signed a lease agreement with this private developer to build this water park. And they allowed for the development of this water park and this commercial use of this area as long as it's not environmentally sensitive. However, the land is clearly environmentally sensitive, and I'll get into more details about that in a moment. And there was another lawsuit that we were plaintiffs of that challenged the legality of the lease for allowing this water park to be built on environmentally sensitive land. But we won't be getting into that today. We'll be talking about another lawsuit that Elise will cover that significantly contributed to the success of basically eliminating the possibility of this water park being built here. Next slide, please. Oop. Back one slide. There we go. Perfect. All right. So I talked about how the land is environmentally sensitive. So as I said earlier, the county entered into this lease agreement saying that you could use it for commercial development as long as it's not environmentally sensitive, but it clearly is. So the map that you're seeing on the left here is all of Miami-Dade County, and it's showing proposed and critical habitat. So what is critical habitat? Critical habitat refers to specific geographic areas that's essential to the conservation of a listed endangered species. So you see this map on the left here, we have, overlapping critical habitat. The beige color is showing one species, and then the darker red is showing 5 to 7 species of proposed or critical habitat. So as you can see, we have little patches throughout throughout Miami, but in the South Miami location where Zoo Miami is, you could just see it's a biodiverse hotspot. You could see that there's all these different proposed and critical habitat. And what I mean by proposed is what happens is the U.S. Fish and Wildlife Service will issue proposed critical habitat and allows the public to comment on that. And then they will go back and finalize that critical habitat. So the area that was proposed for the Miami Wild development is on and adjacent to land that is vital for endangered species, and it hosts the largest and most biodiverse fragment of the critically endangered pine rocklands outside of Everglades National Park, which is the Richmond Pine Rocklands. The map on the right, I'm so sorry. The map on the right here is showing more of like a zoomed in version of this. So the bold black lines that you're seeing on your screen, that is the Miami Wild's footprint. And you could just see all the different overlap of all the different species. And this is actually an older map. So the proposed critical habitat of the Florida bonneted bat, it's actually final now. It recently came out. And we've learned a lot in the past 10 years about the Florida bonneted bat. So the area that the Zoo Miami uses for parking is actually this great foraging area because it's this big open space. So the Florida bonneted bat, they're this large-bodied bat, and they do like to be able to forage and socialize in large open spaces. So this parking lot, which also had trees and other, tons of different vegetation there, they were using that as this foraging and social site. Zoo Miami is the second large known population for the species across the entire range of the bonneted bat. Next slide, please. And this is also some of the concerns that we had. So the proposed or final critical habitats for federally endangered Bartram scrub hairstreak, which is the top left, Florida leafwing, top right, Carter small flower flax, which is the bottom left photo, and the Florida bricklebush appear to be within or adjacent to that Miami Wild site. So that proposed footprint that we saw. So if you can imagine if you're putting a water theme park in the center of the Richmond Pine Rocklands, and you're just going to create this, really reducing the movement of different species. And it's also really hard to maintain the Pine Rocklands. The pine rocklands rely on prescribed fire. So if you imagine having a water park smack dab in the middle and then having to do these prescribed burns, it'd be pretty difficult to carry out the maintenance that is needed. Next slide. And this little guy is also really important. So the Miami tiger beetle, it was discovered in 1934, but it was not seen again until 2007. It's only found in pine rockland habitat in Miami-Dade County. So we have several areas where the Miami tiger beetle was found, which was some parts actually within the parking lot of Zoo Miami. And then that, if you remember in the map, the overflow parking areas, they were found in that area too. So this is an endangered species that we were concerned that would have significant impacts if a water park was built. Next slide. And the Florida bonneted bat. So I talked about this a little bit briefly, but it's the rarest bat in the United States. It only lives in South Florida. There's about 100, maybe a little bit more individuals that reside near Zoo Miami, and it's, the highest density of the population. So it's really important, imagine again, you're putting a water park here, you're going to be impacting this population of the Florida bonneted bat. All right, and now I'm going to pass it off to Elise.
Thank you, Lauren. Thank you so much for setting the stage for why we're so focused on these little green gems in urban Miami-Dade County. I think that you've really highlighted why this whole campaign and the case are so important. Just as a little bit of background, my organization, the Center for Biological Diversity, is dedicated to protecting all species, great and small, that are hovering on the brink of extinction. And we do that by protecting the lands, waters, and climate that they need to live. Our mission is biocentric. We believe that species have an inherent right to exist, but we also recognize a really deep connection between humans and nature. And we know that protecting natural places and protecting the fabric of life protects us and our communities as well. So the center's role in this matter was to apply federal environmental law expertise to the science and people power that were already on the ground for Miami wilds and to protect these pine rocklands. So I'll say, although I'm focusing on the law, this is only a small piece of a much bigger project that brought together hundreds of people to protect pine rocklands. So I thought I would just share a brief primer of the two laws that came into play in this case to protect the pine rocklands. And the heart of both of these laws, the Endangered Species Act and National Environmental Policy Act, is environmental integrity and informed decision-making. So both of these laws were enacted in the 1970s. In a case called Tennessee Valley Authority versus Hill, the Supreme Court called the Endangered Species Act the most comprehensive legislation for the preservation of endangered species ever enacted by any nation, with the goal to halt and reverse the trend towards species extinction, whatever the cost. That is incredibly awesome. There is no other law like the Endangered Species Act, which is why I am so passionate about it. When Congress enacted this law, they found that various species had been rendered extinct as a consequence of economic growth and development that was untempered by adequate concern and conservation. And their purpose was to provide a program for the conservation of these species. And they do that through a number of sections of the Endangered Species Act. The first one and most important, Section 4, that's how species get protection under the Act. The U.S. Fish and Wildlife Service and the National Marine Fisheries Service jointly work to review species and determine whether they are endangered, which means they are in danger of extinction across all or a significant portion of their range, or whether they're threatened, which means they're likely to become endangered in the foreseeable future. Once a species is listed under the Act, it gets a whole host of protections. They get recovery plans, which are like blueprints to determine what steps need to be taken to protect a species. They also receive protection for their habitat. And they also receive a few other protections that I've outlined here under Section 7 of the Act. All federal agencies are required to consult with the wildlife agencies, Fish and Wildlife Service, and if it's a marine species, National Marine Fisheries Service. And they must ensure that any action that they authorize, fund, or carry out is not likely to jeopardize a species extinction or to destroy or adversely modify their protected critical habitat. So that's a huge, powerful action-forcing part of the law that makes sure federal agencies aren't going to contribute to extinction. Under Section 9, the law limits the ability to take species. And take includes harassing, hunting, shooting, capturing, trapping, killing, collecting, wounding, harming, or attempting to do any of those things. Unless you're either authorized under Section 7, you're a federal agency and you've gone through reviews, or you get a permit under Section 10 of the Act. So individuals who aren't federal agencies have to go through getting a permit from the wildlife agencies, and they have to create these habitat conservation plans to make sure that even if their project accidentally harms or kills species, that overall they're contributing to conservation and they're not dooming a species to extinction. And then finally, most relevant to this matter, Section 11, which allows the enforcement of the Endangered Species Act, and particularly under subsection G, I said every other letter in the alphabet first. Subsection G, citizen suits. Under that section, it says that any person may commence a civil suit on his or her own behalf to enforce the environmental laws under the Endangered Species Act. I'm also going to briefly just touch on the National Environmental Policy Act, which was enacted in 1970. It's known as the federal government's charter for the protection of the human environment. And this law also recognized a profound impact of human activity on the environment, particularly profound influences from population growth, high density urbanization, industrial expansion, resource exploitation, and new and expanding technological advances. And Congress recognized that as we make these advances, we need to be looking before we leap and thinking about the consequences of the things we do before we take action. And so under the National Environmental Policy Act, or NEPA, federal agencies must take a hard look at the major federal actions that significantly affect the quality of the human environment. And they normally do that through a document called an environmental impact statement. Though if an agency is unsure whether they'll have significant effects through their actions, they can create an EA, an environmental assessment. And if they determine that it won't have any impacts, they can make a finding of no significant impact, a FONSI, as you can see on the slide there. They can also categorize certain actions which are so de minimis that they don't have major environmental impacts. But overall, they have to go through some process to make sure that their actions won't cause these massive environmental impacts. So this slide is something of a love letter to these laws. I love learning about them. I love using them. But I think the key takeaway here is that the idea of poorly planned development harming the environment and communities is not new. Congress was worried about that decades ago, and they realized that thoughtful planning and public access to information is the antidote to poor planning. And you'll see that play out a little bit in this case study here. Next slide, please. So taking these laws and looking at these pine rocklands in Miami-Dade County and the proposed water park, the first thing we need in order to apply those laws would be a federal action. And in this case, the federal action was taken by the National Park Service. I know that sounds confusing, right? Well, Miami-Dade County wanted to build this entertainment district, specifically a water park, in a site adjacent to Zoo Miami. But that site had a really interesting history. It was previously federal land owned by the Department of Defense, then given to National Park Service. And in the 70s and 80s, National Park Service conveyed that land to the county through the Lands to Parks program. But that transfer of ownership came with conditions. And the conditions were that this property needed to be used for public park or public recreational purposes, and that it may not be sold, leased, assigned, or otherwise disposed of unless it's to another government agency that can maintain it for public park and recreational uses. So as you can imagine, taking this property and using it for a private enterprise, a water park, would not be allowed with those land use restrictions in place. So the county asked the National Park Service to enter an agreement to take those land use restrictions off the property and put them somewhere else, so that the project could move forward. And ultimately in 2022, that's exactly what happened. Park Service released those restrictions, and that led the way for the project. It was then and only then that Miami-Dade County could then enter a development agreement with the water park developer. It's also worth noting that even without a federal action, there were still mounting evidence about risk of take of species. So even if Park Service hadn't been involved, there certainly would have needed to be a review of the counties and the developers' actions to ensure that the harm and even death of some of these species was being accounted for and that there was a habitat conservation plan in place. All right, we can move on to the next slide, please. So just to quickly rehash what Lauren has already very, adequately and eloquently covered, there are so many environmental resources in this area. We know that the pine rocklands are one of the most endangered ecosystems in Florida, in the world even. We know that some of them overlapped with the proposed development site, and we also know that many of them were directly adjacent. And it's important to recognize that even if those forests were not paved over or plowed over by a bulldozer, there are true impacts that happen from having a development directly adjacent to these forests. For one, these forests thrive on natural fires. You need to light them on fire regularly to keep them healthy. And when you have a water park, you have retail, hotels, it becomes very difficult to manage with fire, as you might imagine. And there's also the risk of use of pesticides on landscaping and light impacts for the bats. They need dark skies to hunt at night. And as soon as you've got these tall water slides, you've got these bright lights, it becomes a real concern for the bats and for their prey, all the insects that they eat. Next slide, please. I'm just going to quickly hash over this. Please don't feel like you need to read this, but this is just to show that there was abundant evidence that there were endangered species and important environmental assets near and around and on the site. This is within the area called the Richmond Pine Rocklands, which Lauren mentioned, and the U.S. Fish and Wildlife Service has identified 17 federally protected species in the Richmond Pine Rocklands. One of the species on there, the rimrock crown snake, was not slated for federal protection at the time and is now proposed for endangered species listing and will likely receive that protection later this year. We're still learning even more, and it's very likely there's even more species that need to be protected that live in these pine rocklands. Specifically, Fish and Wildlife Service noted a few threats: the loss of foraging habitat for the bat, the loss and fragmentation of habitat for the Miami tiger beetle, that little shiny rice-sized beetle, as well as having this development hampering the fires that are needed to keep these forests healthy. Interestingly, not only did Fish and Wildlife Service share this information with Park Service before it made its decision, but so did Tropical Audubon Society and Bat Conservation International. So there was a very strong record that the agency needed to look at the environmental effects of the project before they removed the land use restrictions from the site that allowed the development plans to go forward. Next slide, please. I'll just take a quick moment on this one. Lauren really already covered the vast biodiversity in this area, but I just wanted to point out another map showing all the layers of protected habitat in this area. I've never seen a place that has this much protected habitat for this many species in one place. And also that sunset picture there on the left shows you just how dark it gets over the site and why it's such a unique place for the endangered Florida bonneted bat. Next slide, please. So with all of this information we had about the environmental importance of the site and knowing that National Park Service hadn't done its environmental reviews, the center, the Tropical Audubon Society, and Bat Conservation International notified the Park Service and the county and the developer of our intent to sue. That was back in August 2022, just a few months after the land use restrictions had been released on the site. And that's a prerequisite of the Endangered Species Act to give 60 days notice before you file a suit. And that is so an agency has the opportunity to fix the problem. And sometimes that does happen. Unfortunately here, the problem was not rectified. And so the parties being the center and the other nonprofits, had to file a lawsuit in February of 2023. And we filed 3 pretty straightforward claims. One of them was failure to take a hard look at the environmental impacts under the National Environmental Policy Act, failure to consult with the U.S. Fish and Wildlife Service to ensure against jeopardy for those endangered species living on and around the site. And the third one was that the National Park Service made an irreversible and irretrievable commitment of resources, something they're not allowed to do until they complete a consultation. Next slide, please. So what's kind of interesting about this case is that it's intended to enforce federal environmental laws for federal agencies, but we found that it also influenced Miami-Dade County itself. And I won't go through this ginormous timeline, but I'll just sort of give you an overview. After the suit was filed in June 2023, the county actually intervened in the case and notified the court that it was preparing an agenda item to go before the Board of County Commissioners to try to rescind that agreement with National Park Service, the agreement that we were suing over, and to commit the county to an amended development agreement with the developers so they could keep their plans in place and try to go back and do those federal environmental reviews. So this put the merits briefing of our case on hold for several months so that the county could try to pull together and have a vote on this item. On September 6th, when that vote came up, there was massive public opposition to the project because at this point, there was so much information available about the environmental harm that would come from putting this water park amidst these pine rocklands in the Richmond tract. And so the commissioners ultimately deferred the vote on the item. And then it kicked off a series of deferrals that went all the way to December 12th. In the meantime, following the plaintiff's motion for summary judgment in the case, so deciding the merits, the county attempted to bring the developer into the case and to try to have the federal court announce that this lease and development agreement would be invalid if the plaintiffs were to prevail in their case. On November 4th, hundreds of community members convened in the Zoo Miami parking lot to rally in support of the pine rocklands and endangered plants and animals living there. And on November 14th, Miami-Dade Mayor Cava recommended rescinding that development agreement with the developer if the court ruled in the environmental plaintiff's favor in the federal case. She also detailed the developer's alleged defaults on the agreement, the development agreement itself. So a lot was going on at the county level while the federal case was pending. Next slide, please. And that takes us to our ruling. In December, a day before the county commission was to vote on the item that they had been deferring, the federal court entered an order in favor of the environmental plaintiffs. The court found that the agency, National Park Service, had failed to take a hard look at environmental effects under the National Environmental Policy Act and had failed to consult in compliance with the Endangered Species Act. Judge Seitz, who ruled on the case, ultimately did not rule on claim 3, just denied it as moot, finding that the plaintiffs had already received all of the remedy that they had asked for based on the first 2 claims. And so if you could move to the next slide, please. So ultimately, the outcome of the decision was, well, one day before the court's decision, U.S. Fish and Wildlife Service actually weighed in and affirmed the ecological importance of the site, because at this point, there was a lot of public pressure. There was a lot of requests for information about what was going on with the site. And so the wildlife experts weighed in. On December 11th, that same day, the court vacated National Park Service's agreement and release. And in vacating that release of land use restrictions, that also affected the development agreement between the county and the developer. And so on December 12th, the Miami-Dade County Commission declined to vote on the proposed lease amendment in light of the federal decision. And during that meeting, the mayor indicated an intent to rescind that development agreement with the water park developer. And sure enough, January 18th, the following year, Mayor Cava notified Miami Wilds LLC of rescission of that development lease agreement. So I think I have one more slide here just to try to tie a little bow on this. Thank you. So what does this have to do with good wildlife policy implementation? The federal agency didn't follow the law. Well, I think this is really a great example of how citizen intervention and enforcing these laws is critically important to vindicate the intent of Congress. Here we had public enforcement of environmental laws. We had individuals, organizations come forward and say, Congress wanted us to protect endangered species and to protect the environment for our communities, and you didn't do that here. So we're going to ask a court to step in and rectify that problem, and that's exactly what happened. There was also increased public awareness in just talking about this legal violation. Many people became aware that there were even endangered species at the site. The Florida bonneted bat, the Miami tiger beetle became poster children for protecting pine rocklands. It also led to better informed government decision-making. Throughout the course of this case, we saw the Miami-Dade County commissioners have a change of heart and decide not to pursue this project anymore. And that's in large part because of all the information that was brought to light and the people who came to the table and said what they wanted for their own communities. And finally, this offers an opportunity to pursue a new direction, which is long-term protection, management, and restoration of these incredible biodiverse forests that we have nowhere else on Earth. And that benefits biodiversity, of course, the recovery of these endangered and threatened species, but it also offers relief from the urban heat island effect. Communities that get so hot from all the pavement and concrete buildings have these green places that they can recreate and relax in. It also just cools off the surrounding areas where people live. Opportunities for recreation abound in these places. And this is also an opportunity for children who live in an urban area to learn about endangered species in their own backyard. And then finally, and maybe most exciting, is one of the biggest fragments is right by Zoo Miami. So there's incredible opportunities for sustainable tourism and building communities not on the exploitation of environmental resources, but on uplifting and investing in them. And so I'll leave that there. This is sort of the story of a completed arc, and then beginning the next steps towards this proactive conservation. And I think this will be a helpful lead in to the next item that Elizabeth will be sharing with you. Thank you.
Thanks, Elise. So I'm just going to chime in quick here too. So that was covered so eloquently and beautifully. I just want to talk about how all the different pieces that came together here. So we not only, we did this rally, as you see in these pictures here, but we wrote opinion pieces. We had public meetings where the public came and we educated all about this and the issues with this project. And one of the big, I think, turning points as well is we had influencers actually get involved. So Ron McGill, who's in the top left here, he's talking on the stage in that photo. He's an American wildlife photographer and the communications director of Zoo Miami. And when this project was originally proposed back in like 2006, he actually thought it was a good idea. It was a way to generate money for the zoo, have like another during the off seasons, people come to the water park, you could generate more money. They'd make some money off of the people paying for parking and other ways to get the people to go to the zoo. So he originally thought it was a good idea, but then as more information came out, he's realizing, oh my gosh, we have all these species here. There's just more science and more information coming out. So what ended up happening is Ron showed up to one of our public meetings that we had at Tropical Audubon, and he said he's going to speak out against the zoo and this project as a private citizen. And that was huge because the zoo is under Miami-Dade County's Parks and Recreations Department, so he really shouldn't be speaking out, but he spoke out as a private citizen, not representing the zoo, and he has a large following. So he was on the news for this. A lot had happened to make even this rally a success. So the rally you're seeing in the photos too, there's over 300 people. I think it was, 350 or so that attended and spoke, marched in opposition of the project. We also had Luca Martinez. He's a social media influencer with millions of followers. He joined the fight as well. And Tropical Audubon had an action alert where he had this amazing videography piece of all the pine rocklands and the species and how this project will impact them. And then he linked our action alert. So we had the most ever with our action alert. It's where someone could basically take action. They could send a letter to county commissioners saying they're against the project. They could just by one click. And we had thousands and thousands and thousands of people taking action in these emails going to the commissioners. Next slide. And then I will close here. So we just wanted to talk about quickly with, this is us at the commission meeting. And this was a successful campaign because of our amazing partners. It was Tropical Audubon brought the organizing of the people and like the soldiers ready to go. Bat Conservation International brought that scientific expertise. The Center for Biological Diversity was brought the litigation, which really was that secret sauce to kind of putting an end to this. And you don't have to be all of these things, but each thing brought something different for the success of, defeating the project. And now, as Elise had mentioned, there's a segment of the community that's ready to support a long-term conservation for this particular area. And those are kind of the next steps that we're looking forward to moving to protect this area in perpetuity. All right, and I will pass it off to Elizabeth to talk about the South Dade Logistics and Technology District.
Thanks, Lauren and Elise, and thank you, Yvette, in the Animal Law section for having us. Elizabeth Fata-Carpenter, Executive Director of the Everglades Law Center. Everglades Law Center's mission is to advocate, negotiate, and when necessary, litigate to protect and restore South Florida's ecosystems and communities. And we are a nonprofit law firm practicing in the geographic area of the historic Everglades ecosystem. So essentially Orlando all the way down to the Keys. So I'm excited to talk about the South-Dade Logistics Center issues. One, because, we're dealing with wildlife and environmental issues, but it's not a Clean Water Act suit or an environmental or an Endangered Species Act suit. It's a land use and development suit. I think it's a good example of how different regulatory and legal handles can be used to address issues that we're dealing with wildlife in our environment. So I'm going to talk a little bit about what the project is. Lauren is going to get into the reason that we oppose the project, and then I can come back and talk about the community impacts and the community advocacy and legal tools that we use to oppose the project. Next slide. All right, so kind of starting high level on the regulatory world that we're in with this project. In the state of Florida, all local governments are required to create what is called a comprehensive development master plan. And the local government uses this as an overarching land use, growth, and urban development plan. And it's also called CDMP. The CDMP outlines general objectives and policies addressing how and where the local government intends to develop or conserve land and natural resources for the next 10 to 20 years. So it's essentially the local government's plan. In Miami-Dade County, within the CDMP, we have what is called the urban development boundary. And the UDB identifies the area where urban development may occur through the year 2030. So it's a 10-year at a time plan. And if you look to the image on the right, you'll see the big black line on the west side of Miami-Dade County. And that is the urban development boundary. And so that basically says east of the urban development boundary, where our urban core is, development, growth, and expansion are permitted, but we're not going to allow that same type of development outside of the line for many reasons, including economic. It's a poor use of public resources and tax dollars to sprawl and require the development of infrastructure, water, hospitals, emergency systems in a spread out, non-dense way. And also, where this project importantly comes into play is for the environmental and wildlife implications. So the UDB protects land outside of that land. We always talk about it being important buffer lands for Everglades National Park, Biscayne National Park, and our wild areas, protects wetlands, agriculture, preserves open land for water quality improvements. Very importantly, it is also where our drinking water wells are. And so open land in this area is absolutely necessary to recharge our drinking water areas where we supply water from the Everglades for 9 million people. And of course, it creates natural habitat for wildlife. And as Lauren and Elise were discussing, it is the home of a lot of critical habitat for a number of species. So now that next slide, please. Now that we've laid the framework on what the CDMP is and what the UDB is, let's talk about the specific project. So developers came to Miami-Dade County and proposed the South-Dade Logistic and Technology District, which was originally proposed as an 800-acre industrial site outside of the urban development boundary. And if you look at the map on the right, you can see that red star at the bottom. So again, initially proposed at 800 acres, following a lot of public pushback, which Lauren will get into, the footprint was reduced to 400 acres. But in order to build an industrial complex like this, you need to be inside of the UDB. It's not permitted outside of that. So the developers went to the county and said, I want to build this project. I want to therefore expand the UDB so I can move forward with this. However, Miami-Dade County's own CDMP says you can't expand the urban development boundary unless there is a need, which means that there's not enough land within the urban development boundary for this type of use. So in this case, there was enough industrial land inside of the urban development boundary for this development. And so expansion of the UDB was unnecessary. It's also some pretty significant environmental and wildlife impacts that we're going to discuss, and I'll turn over to Lauren to kind of highlight those, and then I'll jump back into the legal posture of the case.
Perfect. Thanks, Elizabeth. Yvette, next slide, please. Thank you. All right. So, this project, like Elizabeth already had stated, but there's enough land within the UDB to do this project. But more concerns that we had is that the land proposed for the project falls within the BBC project, or the Biscayne Bay Southeastern Everglades Ecosystem Restoration Project. And it falls within that footprint. So essentially that means that the land used for this project is vital to Everglades restoration efforts. The property had been flagged for us as a water preserve area in basically every component, every alternative of BBCR. And it's one of the best performing components of BBCR and modeling runs as it currently stands. So also this property would be utilized to improve water quality, quantity, and salinity to restore nearshore habitats in Biscayne Bay. The C-102 canal, which is a component within BBCR, flows directly through this property and to Biscayne Bay. So if you can imagine putting an industrial site there isn't the best for Biscayne Bay health. Further, this land is within a coastal high hazard area. So that's an area that has hazards due to wave and wind action. So again, not the best decision to put an industrial complex there. And it's also near Biscayne Bay coastal wetlands and adjacent to wetlands of regional significance by the county. It poses risk to wetlands, flooding, and storm management. And it also poses impact to important species and water resources. So specifically, the Florida Fish and Wildlife Conservation Commission identified the potential for multiple endangered and threatened species that could use that site. It's a core foraging area for the wood stork and nesting colonies for the wood stork. It's an Endangered Species Act consultation area for the Florida bonneted bat that we had covered earlier, and potential habitat for the eastern indigo snake. And throughout the whole application process, the developer did not demonstrate how any of those resources will be protected. Next slide, please.
Lauren, can I jump in with one more thing on BBCR before you jump to community advocacy?
Yep, go for it.
So something, on this great slide Lauren has, another important part of this is not just the localized impacts of that area, but BBCR intends to redistribute water across all of Miami-Dade County. So you can see that orange line that goes from the north to the west. So by developing in this really critical component of BBCR, you're essentially putting like a huge roadblock in the middle of this water distribution system for the entire county.
Perfect. Thank you, Elizabeth. Okay, so obviously with all of those concerns in mind, the public was really, really upset about this potential project. And as Yvette had mentioned earlier at the beginning, the urban development boundary line has not been expanded since 2013. So asking for this massive project to do that was upsetting to the community because of all those issues there. So we had so many different advocacy efforts. We showed up at all the county commission meetings. Tropical Audubon also issued an action alert. So that's where, again, as I talked about earlier, it's where anybody can basically send a quick letter to all the commissioners saying they're against this project. It's like an easy click action. And due to this, it was multiple deferrals. And essentially the applicant kept requesting for deferrals because they knew they did not have the commission vote to pass it. All that public pushback and the action alerts and all those things, actually it was helpful. It reduced the project to by more than half. So it was about 800 acres they proposed originally, and then it was around 350 acres when it was passed. So even though all these advocacy efforts did happen and the project was reduced by half, unfortunately, county commissioners did still pass this project. So that means that they expand urban development boundary line to include this industrial complex. However, I do want to say that all of our advocacy efforts, though, again, reduced the project by half. The applicant also contributed to environmentally endangered lands. So those are lands that are the county is looking to protect. So they contributed a certain amount of acreage within EO lands. And also all of that outcry, there are so many deferrals of this application that one of the commissioners said enough is enough. There needs to be a change in procedure. You cannot just defer and defer and defer an application. So Danielle Cohen-Higgins of District 8, the commissioner, she changed the procedure that you could only request up to 3 deferrals. If by the 3rd deferral, you still don't have, the commission, decides to not, they can either decide not to pass it or the application is just withdrawn. You can't just continuously ask for a deferral. So again, the project did move forward, but now I'll pass it back to Elizabeth for how we reacted to that moving forward.
Thanks, Lauren. Yes, so I know we're a little short on time, so I'm going to run through this really quickly. But if there's any questions on the details, I can jump into those details a little bit more at the end if folks are interested in that. So as Lauren said, unfortunately, the application was approved. So when the advocacy fails, the next step's litigation. So the Everglades Law Center, along with our wonderful co-counsels Paul Schwepp and Richard Grosso, filed an administrative petition challenging the county commission's approval of the South State Logistics Center in administrative courts. And we challenged it on about 6 broad issues, essentially all of them related to the fact that the approval is inconsistent with Miami-Dade County's own CDMP. And anytime you amend the CDMP, a requirement under Florida law is that the amendment has to be consistent with the rest of the document. Makes sense. So as we discussed, there was no need to expand the UDB in the first place. Miami-Dade County's own staff recommended a denial of this application because it was inconsistent with their CDMP. The state of Florida asked the county commission to deny it, and the federal government asked the commission to deny it. And so a lot of the things, each entity had slightly different concerns, but a lot of the things that were flagged by the various government entities and the county commission staff were encompassed in this administrative petition. So no need. This was a development in a coastal high hazard area, which the CDMP does not allow and is just frankly bad planning. Impacts Everglades restoration, BBCR, and the restoration of Biscayne Bay, as we discussed. Impacts agriculture, encourages sprawl, which is the poor use of public resources, and it's dangerous, frankly. And it threatens water quality and our public assets. And just to put a real pin on this being one of the most important components of BBCR, it would stop the flow of water into this area in Biscayne Bay for a very large region. All right, so we filed this administrative suit, and while we were getting ready to litigate with the county and the developers, the state of Florida actually stepped in. Next slide. So we're gearing up for a night's administrative trial, and the Florida Department of Economic Opportunity, which is the state land use agency in charge of managing the local government CDMPs, received the final application from Miami-Dade County, and in their final review of that application, sent a letter to the county saying, actually, in fact, we're not speaking to the substance of what was approved here, but you didn't comply with the procedural requirements, and you failed to approve the application within the 180 days required under Florida statute. So just to highlight that provision really quickly, the local government shall hold its second public hearing after it's transmitted to the state, which shall be a hearing on whether to adopt one or more comprehensive plan amendments. If the local government fails within 180 days after receipt of agency comments to hold the second public hearing, the amendment shall be deemed withdrawn. So after a series of letters between ourselves, the county, and the state, we were left in a very interesting procedural posture because our administrative challenge was based on an approved application and focused on the substance of it. But the state informed the county that there actually was no approved application. So the county, also in an odd procedural posture, filed a deck action along with the developers, asking a court to tell them what the state's letter means and the impact on the application. They argued that the 180 days was extended initially, and because as Lauren mentioned, there were so many deferrals, that initial extension was exceeded. This was over like almost 2 years of deferrals and back and forth and an extension. So they argue that the very first hearing they had should have counted for the 180-day requirement, and then the county would be permitted to hold hearings in perpetuity without any time limitations. Next slide. No, I'm running out of time here. So after the county filed this deck action, we asked the administrative court to stay the proceeding because if there was no application approved in the first place, there was no reason to challenge the substantive components of that. So the administrative court stayed the proceeding, and on behalf of our client, Dr. Lewis, we moved to intervene in the deck action because, frankly, the outcome of the deck action 100% impacted the administrative case, as just discussed. So the developers in the county opposed our intervention, but it was ultimately granted. We participated in briefing, summary judgment, and this was heard by the court on summary judgment. And ultimately, the judge ruled in our favor and the state's favor on all counts of the deck action and our cross motions for summary judgment, and found that the county had failed to comply with the 180-day requirement. And as such, the application was deemed withdrawn and a nullity. You can see a couple excerpts here from that final order. So a huge win for the opposition of this development. Of course, the county and developers have appealed, and that is now pending on appeal. But next slide, Yvette, please. But as it stands today, there is no approved application, and BBCR continues to move forward with its planning process. And as of May 17th, which is just a few weeks ago, the particular piece of land we're talking about, which is a photo in the left, is included in the final 2 rounds of BBCR, and again, is one of the best performing pieces of land as a water preservation area in BBCR for the restoration of Biscayne Bay, Florida Bay, and really the entire water distribution of Miami-Dade County. So, of course, we have to wait for the pending appeal, but this is a huge win, and it is allowing BBCR to continue moving forward with this modeling and move towards a final plan that would, create an even stronger barrier for any future developments in this area. It's a huge win. Jump quickly to takeaways before we run out of time. As you know, I think Lauren and Elise just did a phenomenal job discussing the community and grassroots advocacy and the value of it in the Miami Wilds program, as well as in the South Dade Logistics Center. And I just highlight what an invaluable partnership those efforts are. You need to, you're often outnumbered by a lot of money, and you need to attack and address these issues from all fronts with the community and the legal work. Always look at procedural and substantive requirements, as the state of Florida did. Keep an eye on what the legislature is doing. I didn't get into this very much, but as we were litigating this case, the legislature introduced multiple bills attempting to retroactively change the law that would have automatically made the application effective, regardless of the existing statutory requirements. They also tried to, or they actually were successful in passing an attorney's fees provision that will apply in the future, not retroactively, for challenges brought like this, that will make it significantly harder for environmental advocates to challenge these. And so we had to kind of watch what was happening in real time to make sure that our legal strategy wasn't changing. And then, of course, be thinking ahead when you're starting with grassroots and community advocacy. Be thinking strategically ahead on your next steps. That is it. Thank you guys so much. Turn it back over to you, Yvette.
Thank you, Elizabeth. And I'm sorry you had to rush through all that because, but you did an excellent job. Let me stop sharing the screen here. So every time I listen to these ladies, I learn something new about these projects and the law here in Florida, and I'm grateful to them. Again, I just appreciate you guys so much for taking the time out and going through these issues for our community and constantly fighting for our environment and our biodiversity and ecosystems. For those of you attending that joined late, the CLE code again is 8522, and it's for 1 hour. I'm going to take a look quickly because we do have a few minutes at the questions. So we have 2 questions from the same attendee. What is the full case name so that they can track the appeals case? And I think that's to Elizabeth.
Yeah, great question. So if I don't know, we stopped sharing, but on the slides, it's a complicated name. It's Miami-Dade County, aligned real estate developers, and all of the rest of the developers. I think the easiest way to look it up is the Florida Department of Economic Opportunity as the defendant. I can send around the case number. I see that what I attached to didn't have the updated case number.
Okay. I think if you want to put it in like I don't know if there's a chat. Yeah, there's a chat if you want to put the case number in the chat for them. And then the other question I answered, which was the CLE number. All right. So lastly, if you aren't, sorry, Elizabeth, did you want to say it out loud?
Sure. It's a 2023 CA 1487.
Okay, perfect. Thank you. If any of the attendees are not a member of our section, but enjoyed today's event, please look into joining. The animal law section of the Florida Bar has so much informative, fun, and creative events regarding the animals of our state and the environment. You can find more information on the Florida Bar website. And if you are a member, make sure to join our LinkedIn page so that you keep up with what we have going on for you all. And lastly, the annual The Florida Bar's annual convention is in Orlando next week. I hope to see some of you there. I will personally be speaking on the Endangered Species Act on Friday, the 21st at 1 p.m. And thank you all for joining and taking the time and being interested in a topic that is so near and dear to my heart. Enjoy the rest of your day, everyone.
Thank you.
Thank you so much.
Thank you.